25 minutes before 11 o'clock. Nice looking Wednesday morning. It is March 6, 2013. I tell you the date because I want you to know if you're listening to a live show or not. And if it's March 6, 2013 where you are, then you're listening to a live show. And that's important because that means you can call in if it's live. John Fuller is here to answer your questions. He, of course, is an attorney here in Ocala at his own law firm. It is called Fuller & Fuller. The other Fuller is Janet Fuller, and she's not only an attorney, but she's also a registered nurse. And it sounds like John has some medical background, too. He just kind of revealed to us. The show is called Legally Yours, and the phone number to call in right now is the WOCA Climate Control Source Hotline, 352-622-9622. Good morning, John.
Good morning, and I have no medical background. I worked as a ward tech, which is a scut puppy at Shands back in the 60s, so that meant that I was an errand boy for doing all the dirty work that nobody else in the hospital wanted to do. So I do a lot of cases involving medical issues, and I do have contact with a lot of very well-trained physicians and people in the medical field, and I have been exposed to a lot of medical terms, and my undergraduate degree was in zoology, and so I have some background in anatomy and physiology.
Oh, wow.
But I, don't call me and complain of symptoms. My closest knowledge to it was 2 weeks ago when we missed the show. I had a case, and when it was in court, couldn't be here. Last week I had bad case of the flu and completely lost my voice. And in my work, without a voice, Larry, is just like you.
That's
without
right.
a voice in yours, you just can't function.
So you can't function without a voice and without a brain. I can't. It doesn't matter whether I have a brain or not. It's just the voice is all.
They both help, but I can understand. When you're sick, you're sick. So
Yeah.
It's nice to be here. It's a beautiful day, and I hope all of our listeners and their families are all staying well and healthy, and aren't having legal problems. But if they are having legal issues or they have questions about legal issues, we're delighted to talk with them about them. We have some really great listeners who call in with great questions. So yes, we are here live in living color, and we hope that if anyone has a question, they'll call in.
One of the things that in all the weeks we've done this show together that I don't think we've ever talked about, and it's one of those things that you always think about going to an attorney for, but it has nothing to do with being in trouble. It's got to do with the contract and asking, like a lot of times, like you get a contract whether it's from a real estate agent or like this morning we had this guy talking about Ponzi schemes and how these people got wrapped into these contracts. So a lot of people, I'm guessing, will contact an attorney to say, would you look at my contract for me and tell me whether I should sign it or not? Something as blunt as that.
Yeah,
do you get that kind of...
Well, I do litigation work. I specialize, and I'm board certified in civil litigation and in business and commercial litigation. So I do just trial work involving cases of accident or injury cases, people who have disputes in commercial matters and business matters, and those involve lawsuits, disputes, in many cases, over contractual disputes. Okay?
So the contract does play a role.
So it plays a role in that we are arguing it's valid, it's invalid, it's enforceable, it's not enforceable, it's been breached, it's vague, it's indefinite, it's uncertain, there was no consideration for it. A whole bunch of things of that nature go into litigation of contract issues, and that's a large part of what I do. From the standpoint of drafting contracts, that's a more transactional matter. But you raise a wonderful point, because by the time a dispute arises over a contract, the contract is already signed, and I have to deal with it for better or worse.
Yeah, that's
okay?
right. That's right.
It's kind of like the old commercial for the oil filter, pay me now or pay me later. A small amount of money to take preventative maintenance often saves a large amount of money in litigation, because a lawsuit is very expensive. There's a very fine lawyer in Ocala who's a mediator, and he's very experienced in the thoroughbred horse industry. And he has a saying that I love, and I'm quoting him, that he used to say that horse racing was considered the sport of kings, because usually no one but a king or queen could afford to get into thoroughbred horse racing, because it's a very expensive hobby. But he said the real sport of kings is litigation, because it is so expensive. And he says that in the context of encouraging people to mediate their disputes and reach a compromise. You're absolutely right. You make a very good point. If people are contemplating any kind of business or other relationship between themselves, employer-employee, tenant, landlord type thing, any type of contract, everything you sign, an insurance policy, anything that you sign is a contract. And the terms of that contract, if it's valid, are going to control what the judge ultimately has to do in determining who's right and wrong in a dispute. Because he cannot, the judge, the court, cannot go off of what's called the four corners of the contract. That means within the body of the contract itself. Think of a page. If the term or provision that governs what the two parties are to do in relationship to each other, if it spells it out and it's not otherwise deemed to be invalid or unenforceable for any other reason, then the court's duty is to enforce that contract. He can do one of two things. You can file suit, in most cases in a contract action, for specific performance, which says to the judge, I have a contract. I've done what I'm supposed to do, but the other party has not. Judge, I want you to enter an order making him do what he said he would do in the contract. That's specific performance. Now, there's some exceptions to that. Personal service contracts are an exception. If you have a contract to paint somebody a picture and you decide for whatever reason you just don't want to paint that picture, the judge cannot enter specific performance to order the performance of a personal service. However, you have a remedy for breach of contract damages. And if you had a contract with someone to paint a picture, and you could sell that picture in your art gallery, say, and make a profit, and they refuse or fail to paint the picture, and you lose money, then you have a lawsuit for damages. So if you have a contract, take it to a lawyer who specializes. If it's a real estate contract, go to a real estate lawyer. If it's some other type of contract, go to a lawyer who specializes in that type of transaction. If it's a contract involving the formation of a corporation, a partnership, a limited corporation, a limited partnership, any of those type things, it's important that you have help in drafting the contract. An ideally drafted contract tries to understand what it is that the two parties are agreeing to and spell that out with clarity, then anticipate all potential future contingencies that could happen arising out of that relationship and that agreement, and find out how they want to handle it, and then spell it out in the contract so that they know what they're going to do and what their duties and what their responsibilities are and what their entitlements and obligations are. So yes, if you have a contract, first of all, if you don't have a contract and you're entering into an agreement, you can have oral contracts, and oral contracts under certain circumstances are enforceable, but it's much better to have it in writing. And if you're going to sign a written document, it is much better to have it in writing and have somebody review it, because it may have provisions in it that are not what you really wanted to do. I have people come to me, and they have signed a contract.
Or they didn't understand it.
They signed it. Whether
Completely.
they did or they didn't,
Gotcha.
they signed it.
Right.
They read it. They're not incompetent. Ignorance of the law is no excuse. And if somebody didn't create fraud, duress, misrepresentation, or something like that, and they signed it, and then they find out there's something that they don't like. For instance, they signed a contract, and they're all in Marion County, but the contract says that in the event you have a dispute over this, the agreed upon venue or geographical location where you must file the lawsuit is Dade County, Florida. They can't file a lawsuit in Marion County. They have to go down to Dade County
Does
to
that
file
happen?
their lawsuit. Of course it happens.
What, is that like a trick? I mean, do they do that?
No, I mean,
Why would they do that? Why would
because at the time, very likely, they both all lived in Miami.
I got you. Okay.
But somebody ought to say, are you planning on remaining here, or is
Yeah.
this, you contemplate that this is going to be moved to another location, and do you want to put a restrictive venue in it? Because if the contract doesn't have a venue restriction in it, venue is then determined on the technical requirements of Florida law, which is usually where the parties reside, where the property is located, where the transaction takes place, that sort of thing.
Right. Fascinating topic. We do have a phone call. Let's take that phone call. Good morning. You're on the air with John Fuller.
Yes, good morning, John.
Hey, good morning. How are you, sir?
Very good, thank you. I don't know. Recently at the Daytona racetrack, I don't know if you're aware or not, there was quite a serious accident, and pieces and parts of the one of the racing cars had flown into the audience, injuring, I believe, around 30 people. On the back of your ticket stub, very, very fine print, it says not responsible for injury due to this, that, and whatnot. And it was proven that the race facility itself had ample protection, but it can't be 100% assuring an audience that something might not happen. Now, is there any liability there for the race facility, or are you on your own, or how would you look at that?
That's a great question, and it's a complex question. Like so many issues we deal with, there are many layers to that question. Generally speaking, someone who sponsors an activity where there is some degree of potential risk to the patrons, you can limit your risk by having the patron purchase a ticket and have it printed plainly on the back, and it doesn't have to be in any size type, that says that the person who buys the ticket knowingly assumes the risk,
right?
Because there is certain inherent danger of standing or sitting at a racetrack next to automobiles going 250 miles an hour 3 or 4 feet in front of you.
Right.
Now, there are exceptions to everything I say, but the racetrack can limit its liability to a certain extent by having that kind of waiver, and all of those events have that. Now, there are some exceptions under the law that it does not exonerate necessarily from willful, wanton, gross, or reckless negligence.
Okay.
There are also other potential defendants. If, for instance, a race car driver illegally modified his race car so that it did not meet the standards, the safety requirements, did not have the necessary equipment that was required to prevent the car from falling apart or wrecking and going into the stands, they may have a lawsuit against the owner, operator of the race car that is separate and apart from the stands. Mm-hmm. If the racetrack has a ticket that exonerates it from liability, a waiver by buying the ticket and going there, but a third party who constructed the retaining barrier that was supposed to have prevented a safety measure that would have been satisfactory to have absorbed the impact and contained the flying debris to protect people. and that third-party contractor, instead of putting in 4 inches of concrete and rebar, decided to save money and negligently or intentionally only put in 2 inches of concrete, so that the retaining wall was negligently built, you may have a lawsuit against the person who built the contract. There may be these are very complex issues that require substantial investigation of the facts, very thorough legal analysis, and the input of expert witnesses from a variety of different disciplines.
Yeah.
So you ask a very good question. The simple answer to the basic question: if you put on an event where there are known dangers and people come to participate in that and they are injured, they can be held accountable for the assumption of the risk. That's a legal theory that is not formally in vogue anymore, but it has residual vestiges in the law, that when you buy the ticket, you acknowledge that you are waiving any claim that you would have against the person who did it. Same thing for like a rodeo bull rider. Somebody enters to be a contestant in a rodeo, and he's going to get on a 1,500-pound enraged bull and try to ride him for 8 seconds, and he gets thrown off and breaks his neck and is a quadriplegic, and then he wants to sue the person who owns the bull or the rodeo. He's not going to have a very successful case. Now, I had a case a number of years ago where I represented a thoroughbred jockey who was a very, very skilled, competent jockey who was racing a horse, and the racetrack where he was racing the horse, he was breezing the horse, which means running the horse as fast as it can go under controlled circumstances, and he dropped down next to the rail. Well, the rail had been defectively maintained so that it had separated at its joint, and part of it had extended into the race course. And as he goes by on this thoroughbred going about 35 miles an hour, this piece of pipe caught his left ankle and leg and nearly ripped it off, fractured, dislocated it, tore all the tendons, ruptured a lot of vessels. Fortunately, he didn't lose his leg, but he lost a lot of function in his lower extremity. We had a lawsuit against the racetrack, even though they had said you assume the risk. You assume known risks. You don't assume the unknown or unknowing risks.
All right.
I hope that answered your question.
It's
very complex.
From what I've been reading with Daytona there, most of the cases are being settled out of court for the racetrack itself to eliminate the future situations.
And that happens because there's always a business decision component, and if you can settle a lawsuit for, even if it's what's called nuisance value. If I pay a person $5,000 not to sue me, even though I don't owe them $5,000. But if it's going to cost me $50,000 to defend it and take a lot of my time and energy and resources away from my business and create negative publicity, then a lot of business people will make a decision that it is in their best interest to pay monies to get a release, and it is basically called buying your peace. And the release that you sign, that is signed, is that there's no admission of fault, there's no admission of liability. The owner specifically retains his denial of any fault or liability, and it is a settlement of convenience only to buy his peace and to end the controversy.
Okay, thank you very much.
Thanks for calling in. That was a great question, by the way.
Okay, bye now.
So in that case, and kind of attaching that question to the first part of the show today with contracts, the ticket is in essence a contract.
Absolutely. Wonderful point. It is a contract. If you take your car to long-term parking at the airport, and when you punch the little thing and get a ticket and you drive into the airport.
Yeah.
If you look at the back of it, it will have a disclaimer.
And so, in other words, if somebody comes in and
breaks
paints my car, or
breaks your car,
Yeah,
steals
yeah.
your hubcaps, you're
so that's a contract you almost have no choice but to go along with.
yeah, and that's sometimes as a defense that it's a contract of adhesion, meaning that you can't do it.
You can't really negotiate
but you have a choice. You can choose not to park your car
Yeah.
in that parking lot.
I guess so. All right, let's go back to the phone. Good morning. You're on the air with John Fuller.
Hey, good morning, Mr. Fuller. Welcome
morning.
back to the show. Glad
Thank
that
you.
you've been working.
Well, I'm glad to be back. I'm glad to have a voice so I can talk with you good folks, and I really appreciate you calling in this morning.
Basically, this is just a follow-up from a couple of weeks ago. We were discussing automobile insurance and stacking policies and limits of liability.
Right?
And after speaking to you, I did go ahead and get a hold of my insurance agent. We went over a few things, and I increased my automobile liability up to $500. But you suggested inquiring about a personal umbrella policy.
Right. And uninsured motorist coverage. That's very important for you.
Well, right, and I followed through with that, and just, the personal umbrella policy was under $170.
That's very reasonable.
Yeah, and I think I'm fully covered now, and,
Right. Congratulations.
Heads up on that.
Well, I'm so glad you did that. I wish everybody would do that because you would be surprised how much protection you can buy for a very reasonable amount of money. And I will tell you this, and I'm not being disparaging about anybody in the insurance business, but the insurance industry as a whole, they don't like to popularize products that they don't make a lot of money on. And so they don't make a lot of money on uninsured motorist coverage. In fact, they sometimes lose money because people who buy uninsured motorist coverage are usually people like yourself who are careful, conscientious, safe drivers, and you want to protect yourself. The people that end up usually injuring people sometimes live a more reckless, irresponsible life, and they have no assets and they have no insurance. So when they hurt the good guy, so to speak, and I'm using that just as a generic term, if you have uninsured motorists, the insurance company has to pay off more frequently, and their profit margin is less than that. If they sell liability insurance to safe drivers who drive 50 years and never have an accident, every premium you've paid them has been pure profit. So that's why it is so important, and that's why a few years ago the legislature changed the law, because the insurance companies used to not tell you about UM. Or if they did, they'd tell you, well, you can get that, but we can sell you your insurance a whole lot cheaper if you don't get that. And the reason they did it was because they didn't make money on it. And then the legislature passed a law a number of years ago that they had to offer you uninsured motorist coverage in writing, and you had to sign a written rejection that you didn't want it. Otherwise, you were deemed to have it if you got in an accident and needed it. So,
and that's correct. They do ask you to sign that form. Now, the only caveat is in order to get the personal umbrella policy, I had to increase
yes,
the liability.
that is correct.
Otherwise, they wouldn't write the policy.
That is correct, and that's normal, and they have a right to do that because what they do is that umbrella is on what is called the reinsurance market, where other insurance companies come in and provide it, and they don't want to be on the hook for $1 million if the underlying tort person who may be at fault doesn't have a substantial limit, and it usually is $500,000. But I congratulate you on doing that. I think you should sleep a lot better for having done it, and I'm glad that you found what I told you was that it was not cost prohibitive, and you could get a lot of protection that's important to you and your family without having to spend an inordinate amount of money. It's unfortunate that you have to ask that, but in the big scheme of things, we're all deemed responsible for taking care of ourselves.
Well, thanks to the show, I found out about it. You have a great week, and Larry, get on board here and become a responsible motor vehicle operator, Larry. I'll talk to you guys later. All right, bye.
Thank you, and thank you for your kind words, and that really makes me feel good to know that somebody got some benefit, real tangible benefit out of our show.
Yeah, wow, good show today, and it went so quick. I had another question about contracts, but I just don't have time.
We'll be back next week.
So how do we get a hold of you?
Well, our office number is 352-547-4292.
Okay.
For our office in Ocala, our toll-free number is 855-534-2565. We have offices in Ocala and the Villages. If you have a Social Security disability matter or an issue involving an accident case or some business commercial or a complex family law matter, we'll be happy to try to help you.
All right, excellent. John, you take care of yourself. You
Thank you.
You sound like you're just at the tail end of whatever it is you're going through.
Yeah, I'm not in full volume yet, but I can still shout when I need to.
There you go.
Thank you, Larry.
Thank you, John. We'll take a little break and we'll be right back.
Ocala's information station, 1370 WOC.